Start off with George Zaske, who is going to talk to us about guardianship. We're using a live binder today for our presentation. So this is George's presentation. And George, whenever you're ready, you can proceed.
Thank you, Caroline. Hello, everyone. I'm looking at the count. It looks like we have 46 attendees. I'm just going to visualize you all scattered across the state of Wisconsin. Physically, I'm located real close to the border of Minnesota, River Falls, Wisconsin. I am a practicing attorney. I'm licensed in both Minnesota and Wisconsin. I have been getting more and more involved in guardianship. I've looked at it from a personal level as well as a professional level. And I'm excited to be here to help educate folks about what guardianship is and what it can and maybe cannot do for you. And Caroline is in control of the slide, so I'll just be asking her to advance to the next slide as we go through this process. Okay, Caroline. Next slide. Next slide. I have to do this standard disclaimer. I'm here to educate and provoke thoughtful family discussions, because when you're talking about guardianship in a family for a loved one, it really is a family discussion. It goes into your individual family's values. I'm not here to say a guardianship shouldn't be used. I'm not here to say a guardianship should be used. I'm here to get people to think more deeply about what guardianship means, what it means to the individual, as well as take a little bit longer view of guardianship, because when you put one of these in place, the guardianship order is going to be passed on to somebody else more than likely, because if you're a parent, you're probably significantly older than your child, and at some point in time, somebody else is going to take over that guardianship. So that's something that I don't think everyone ponders and reflects on, is like, oh, what are we handing off to somebody else? It might be another family member. It might be a professional corporate guardian. So that's something that people need to factor in as they decide what kind of guardianship, if any, is necessary for their loved one. And I'm not giving any legal advice that you can rely on. I don't know any of your individual situations. You can't take what I say here and go into court and say, but that disembodied voice back on May 9th said this. So it really is can be very fact specific. So that's my disclaimer. Next slide. I'm not seeing the next slide.
Sorry, George, for some reason, it's not cooperating with me.
That's all right. There we go. All right, a guardianship is started by filing a petition with the court, and the goal of that process is to appoint a guardian for a ward. So when someone turns 18 in our society, they are considered an emancipated adult, and they have all the rights that go along with being adult. The right to make a contract, the right to get married, to do a lot of things that as a minor they can't do. And the concept of guardianship and ward has been around for thousands of years. If you think back in feudal times, if somebody were to pass away, you could have the lord of the manor became the guardian for a minor or for a ward, that because their parents were no longer there. So the concept of guardianship has been around for a very long time, and people even today can be considering it when they do estate planning or create a will when they have minor children. Oftentimes people will put in their will that if, my wife and I are killed in a car accident, for example, we want my brother and his sister to be guardians of our minor children. So that concept is around, and people think of it as substituting a decision maker for the loved one, and in that case the minor children, that they be taken into the home of the uncle and the aunt and raised because the parents are no longer there. So the guardianship can touch even people who don't have someone with a loved one with a cognitive disability. Next.
Sorry, George. I just figured out the problem, so we should be able to move smoothly through the slides now.
Okay. This is actually the first page. I know it's not terribly clear and readable to anybody looking at it on a screen, but I did want to go through this a little bit in terms of what it takes to start one of these, because it is available online. You can get a guardianship petition and download it off the internet. And I think a fair number of families do this because there is a view that maybe having a lawyer is too expensive. There's constrained family resources. So the process can be started rather easily, in my mind, by just going out and downloading the form. And this form is used in a number of different ways. Up at the top, it says it can be a temporary guardianship or it can be a permanent guardianship. But the key point I want to make is that it's the last line in that caption is due to incompetency. And as you go through this, you just, in a sense, check boxes. Line 1, I'm interested as a relative, and then you just list what your relationship is. It could be mom, dad, it could be sister, it could be uncle, it could be a public official, it could be other. Sometimes there are no family members, so they have to have a corporate guardian. There are companies around the state that's their role, their agencies, and they have a caseload, and they become appointed guardians of someone with a cognitive disability. And it identifies where the individual lives. One of these guardianships can start at age 17 and a half. And I think that what happens oftentimes is when you have a child with a cognitive disability, you're getting, they're either a junior or they're a senior, and you're getting at that point of adulthood and stepping off from the school district and the school system into the adult system. And that's really something of a cliff. And you may be in the last IEP, and the team may look at you and say, okay, your child's turning 18. They can exclude you from the IEP unless you have guardianship. You'll start to talk to your medical professionals, and they will say, well, you can't be in the room once they turn 18 unless they give your permission. You also have to, oh, by the way, you should sign up for supplemental security income, and you should contact DVR. And all of these things get thrown at parents around 17 and a half, and I think they, in some instances, become overwhelmed about all that they're going to have to be engaged in, and the power they need to keep their child safe. That's one of the themes that runs through a lot of guardianships, is they see their child as vulnerable and they want to keep them safe, and the way to do that is to get a guardianship. So they will start this process, and it can open a lot of doors to agencies, to governmental systems, the ADRC, because you have authority to make decisions for your child. If you don't go the guardianship route, then you have to use releases and work with your child to support them, which is part of what we're going to talk about today, is the supported decision making. But right now, what people do is oftentimes just get a guardianship. and they'll start this process because they want to keep their child safe. Very legitimate concern, and it's been around for a long time. You'll hear a lot of people advocating for that, and oftentimes this is the first time people start to consider a guardianship and what it means. And they're under a time crunch, and so they go to court and they get this thing done. If you can go to the next slide, Carolyn. All right, and this is the next page. Again, I know it's not terribly readable, but in here it just gives more information to the court about whether or not you want guardianship of the person, or in Wisconsin, we also have guardianship of the estate, and that is getting control of the money, if you will. Some jurisdictions call it a conservatorship, and that's another option, because if you think about it, a lot of influence and control, in the right sense of the word, can be applied if you have some control of the finances. But that's also something that you can apply for, is guardianship of the estate. And down near the bottom is a box that you check if you're looking for a permanent guardianship. And that box gets checked, and then you go down through the next set of pages and check boxes to identify what areas you're asking to switch over control from the individual, who, according to our society at age 18, has all their rights, and you're going to start to check the boxes about which rights you think need to be taken away and given to the guardian. So if you want to go to the next slide, Carolyn. So here you go down and you start checking additional boxes. And one of that number 13 near the top, you identify why the person is alleged to be incompetent and what is the result, as a result of what impairment. And it lists things like developmental disability, serious and persistent mental illness, degenerative brain disorder, or other like incapacities. So here it is, you're making an official document that's going to be part of the court record, where you are alleging your loved one is incompetent. And that is a concept and a term I'd like to expound on a little bit more a little later in this presentation. And then you go down and ask that the individual have a guardianship appointed to them. And if you look at, then in the middle of the page, number 15 talks about guardianship of the person. And here again, checkbox can be pretty simple. You look at it and it's like, oh, it's maybe 3 words, but if you consider what the import is of check in front of those 3 words and what it means, you go down and it says rights to be removed in full under 15A. 1, execute a will. 2, serve on a jury. 3, register to vote or vote in an election. And that's one that I, on a personal crusade level, I have an issue with, because the level of capacity needed to vote is very different than the level of capacity to make a contract. And that's why I wanted to talk a little bit about the concept of incapacity, because if you just take that at one level and check all these boxes, you're really saying that the person has no ability to make any sorts of decisions. And even though some of the decisions we make in life have varying levels of sophistication to them, And in the area of voting, I know a fair number of people who don't put a lot of thought into voting. They're single issue voters. It's perfectly legitimate. We're okay in our society with that. And that's how they vote. They vote based on party. They vote based on an issue. And so there's not a lot of thought process necessarily that goes into it. It's more tied to values. And to say that somebody with a cognitive disability maybe can't work through that with some support, I think is shortchanging them. And it's also available to them to have support in the voting booth. Somebody with a disability can have support in a voting booth. They can't keep somebody out of the voting booth. The only people who can't be in a voting booth with someone is an employer or a union representative. So if your loved one, you don't check that box, they retain their right to vote, but they need help when you go to your local polling place, that can't be stopped. They have the right. Now, if the polling place decides that they think the person is incompetent, they can make that claim, but then that would have to be proven that they don't have the capacity to vote, which is different than the capacity, for example, to make a contract or to enter into marriage. And as you go down that page, rights to be removed by the or exercised by the individual continues. And if we go to the next page, talks about things like medical. Sorry. Yes, that's fine. Go to that page. I forgot. That's where I inserted a different slide. That's all right.
Go ahead.
You can go to the next slide. Yes, some definitions. And this is where I was talking a little bit before on the previous slide about incapacity and terms that get thrown around. And some of these terms, when you're in a legal setting, are terms of art. Some of them have different meanings than maybe a layperson or society in general may have. And this is pulled from the statute. Impairment means developmental disability, serious persistent mental illness, degenerative brain disorder, or other like incapacity. So impairment talks about other like incapacities. And then 15 says incapacity means the inability of an individual effectively to receive and evaluate information or make or communicate a decision with respect to the exercise of a right or power. If you think about impairment, people can have temporary impairments, impaired driving because of alcohol. So when we use some of these terms, we got to think about what context and what venue that we're in when we're using these terms. And number 15 is, I think, really important to think about, is the inability of an individual effectively to receive and evaluate information. Now, maybe your loved one can receive and effectively evaluate information, but it takes them a period of time. So it might be they can't do it quickly, but that should be no reason why they should be deemed in a certain area to lack capacity to make decisions in that particular area. It might be they take longer. They need to see things written down. They need to maybe have pictures. So the idea that, you know, they can't evaluate information, I think needs to be reflected upon to see if, in fact, they can evaluate as it relates to them. And if it goes back to voting, and if they have a view about a particular issue, and they know candidate A supports that and candidate B does not, that should be no reason why they can't exercise their right to vote. And then how to communicate. You know, with technology, there are ways that people can be supported that in the past they were not able to, and so because they lacked the ability to perhaps to communicate, people thought that they were incompetent. And we have examples of that, of people who have been, institutionalized in the past or put under guardianship where, in fact, they had the ability to, make some decisions, communicate it, but they didn't have the means. And I think technology is opening that possibility up. And then what happens at the guardianship hearing is an individual is found incompetent. And that means the person has been adjudicated. There's a finding by a court as meeting the requirements of incompetent. That's also identified in the statute. The guardianship statute is chapter 54 in the state of Wisconsin. So I want to go to the next slide. Now in law, there are different evidentiary burdens. And if you watch TV shows and the crime shows, it's always the burden beyond a reasonable doubt. That's one of the that's the highest level of evidentiary burden. The evidentiary burden in a guardianship is clear and convincing evidence. It's really the medium level of burden of proof, which is more rigorous than the easier standard, which is the preponderance of the evidence. But as it says there, it's less rigorous than the reasonable doubt, which is often used in criminal cases. And in order to meet the standard and prove something by clear and convincing evidence, a party must prove that it is substantially more likely than not that it is true. And this can be employed in certain criminal cases, but for the purposes of our discussion today, that's the standard, clear and convincing evidence. And part of that clear and convincing evidence comes in through what's referred to as the physician's report or the psychologist's report. And what will happen is people may go to their family doctor and they go through the form, and it's another checkbox form you can download off the internet from the court's website. And the form that the physician or the psychologist goes through with the person and more than likely mom or dad, where they look and determine whether this individual can make decisions in areas of finance, in areas of medical, in areas of where they live. And they will, in a sense, check those boxes, and that's part of the evidentiary proof that the person is in need of a guardianship. So we'll go to the next slide. And here's the big long definition of when that was referred to before, 54.10.3. And here the court may appoint a guardian, and these are the factors that have to be proven by clear and convincing evidence. The person is at least 17 years and 9 months. I said you can start at 17 and a half, so the statute allows you to start the petition. It takes some time to go through the process, to have the physician's report done, to gather your evidence, and to get on the court calendar. So 3 months can go by rather quickly before you actually get a court date. And in there, it's the appointment of a guardian to be able to make decisions because the person is found incompetent and vulnerable. And you can see like point A, B, and C has property that will be dissipated. That's one of the concerns. They'll be financially vulnerable. They have money in their bank account. Somebody will talk them out of it. They're unable to work so that they can't provide support for themselves. They'll be homeless if they don't have a guardian to help them be supported to get benefits through the ADRC or through the state, and again to prevent financial exploitation. Those factors in our world can be, I think, changing a little bit. Individuals unable to provide for his or her support. Well, you've seen a big push now for employment for people with disabilities. Maybe they're going to be able to provide some of their support. And what does that mean? How do they engage in employment. And so the world is changing in terms of what's available for people with disabilities, as well as for how they can interact with that world. And so what you have is an individual through this process is found incompetent, and there are guardianship letters that are generated, and then somebody takes over their decision making. And that is a very powerful power. And when you're a parent, it can seem like it's just a continuation of what you do that you've always done. Watched out for them, loved them, cared for them. But at 18 in our society, there's a point that they transitioned into adulthood, and the guardianship process steps in front of that. And again, it may be appropriate, but maybe it's not. Maybe certainly not a full guardianship. And oftentimes the guardianships that are put in place are full guardianships. So if you can go to the next slide. So here's a little bit about, as I was talking earlier, about the right to register to vote or vote in an election. Again, finding that the person is incapable of understanding the objective of the elective process. And this gets back to, I had a case where a young person was put under guardianship. Parents went through it by themselves, and that box was checked. And afterwards, that young person was quite upset because they wanted to vote. And their teacher was actually surprised because this individual showed an interest, knew about the different elective offices, followed politics. That was their thing. And they were told that they didn't have the right to vote. It was taken away in this process, and they were not happy. And the parents were upset with themselves because they thought they were doing the right thing, and they were doing the right thing, but this process has pieces to it that if you don't really think about, or you just kind of get swept along, and I've seen it, it's easy to do, full guardianships, because your primary concern is keeping them safe, found that they needed to change that. So they engaged me to help them go back into court and restore this young person's right to vote. And we put together our evidence, and we went into court, and the court found this person had the capacity to vote, and restored their right there in the courtroom. It was one of my happier moments as an attorney to have that opportunity to do that. But again, going back to my earlier point, he still had guardianship and determination of incapacity for other areas, but he certainly was found by a court to have capacity to vote. So that, when you look at this and when you're thinking about this as either an advisor to a family or as a family member, is buried within this 7-page form are really different levels of incapacity. And it's not a one size fits all. So that's a point I really want to bring home. And from an advocacy point of view, I'm a little biased in this. Is, I think there are more people with disabilities who have the right to vote, who have it taken away, and that, I think, impacts their ability to participate in society. And I think that does them a disservice, and I think it does our society a disservice. So if we can go to the next slide. Again, a little bit more about the concept of evaluative capacity. It's, again, in the statute, the functional ability to effectively take in and evaluate information and or use the information to make decisions. Evaluative capacity. Some people, it takes them longer to take in information. Maybe it takes a different format for them to take in the information. And the fact that you may be taking information and you make a decision and it's a poor decision, that's not necessarily meaning that you lack evaluative capacity. We all make bad decisions. The quality of the decision from somebody looking on the outside shouldn't necessarily be determinative of if a person has evaluative capacity. Again, using the voting example, there are people who vote and I look at them and I scratch my head and I say, how is it that you could make that choice? But they do, and that doesn't question their incompetency. So this idea of evaluative capacity in terms of how people take information, how they process it, and then using that information to make a decision is something, again, that families, I believe, should reflect on, because when they sit at home, they look at their loved one and they know that at some level they are able to process information. At some level they are able to make decisions. And when you go into a guardianship hearing, research and studies have shown that there's a level of awareness that people have, even with more significant cognitive disabilities, that they've lost something, that somebody else is going to be making decisions for them. And if somebody else is making decisions for them, why should they engage? They're just going to be told what to do. And when you think about how hard parents work and how hard the individual with a disability works and how hard maybe the IEP team and the school works to help this person acquire as many skills as possible to help them as they go into adulthood, and then we have this process, and in fact that just sort of knocks the wind out of any sails that they may have going into the future. It's recognized by the individual at a particular level. So if we go to the next slide. A place to go to get some information on the Department of Health Services website. There's a guardianship handbook, and in that book it talks about the level of evaluative capacity required to exercise or make a decision can be different for different kinds of rights or decisions. And again, this gets back to the point that maybe harping on a little bit, but having seen and heard about so many full guardianships when that I don't believe is appropriate, I really want to bring home that there is ability even within our own guardianship statute and within our own guardianship process to do limited guardianships. And we can talk a little bit more about that as we go forward here. But there are resources out there, the guidebook being one, where you can get some food for thought, some insights, some things to think about before you check a box that's on that petition as a family member. And why I think it's important that families start looking at this earlier than 17 and a half is because of the pressure that comes with having to make a decision, the looming adulthood that's coming, and the fact that this is a very significant deal. You have gone into court when you go through this process, and you've gotten a determination that your child is incompetent and they can't make their own decisions. And brain research now, and I have a little affinity for this because my son has a rare form of epilepsy, so I've always been interested in following brain science. But neuroscience research shows us that a human brain is not fully developed until age 24, 25. That's for every human. And I don't know about you, but when I was 17, 18, or 19, I made some decisions that I think my parents could have legitimately looked at and said, I wonder if he really does have evaluative capacity. Many of us take time to mature. And what I see happening with guardianships at 17 and a half is that can really throw up a significant roadblock, an impediment, a current that pushes against a person's maturation, maybe restricts their ability to make some decisions, have some failures, and learn from those and mature. And so when we put these in place at 17 and a half with an immature brain, I question whether that's really the right thing to do, whether or not maybe something more limited be put in place and then we revisit it. And that's the area of supported decision making and some of the other processes that will be talked about a little bit later. But it's have examples or have opportunities as your child is 18, 19, 20, 21, 22, 23 to make some of these different kinds of decisions and to be able to determine where they more reasonably and more accurately sit when it comes to their evaluative capacity for finances, for voting, for medical procedures perhaps, for employment. Benefits, where they, what level that they can participate at. And so with that, when I've read those articles and that research about immature brains, it really drove home the point to me is that we need to be careful with these guardianships on the front end, because if you get a determination in court of incapacity, incompetence, and you want to change that, you've got to be able to figure out how to prove that that person can have some decision making in a particular area of life that you said back at 17 and a half or at age 18 they didn't. So undoing, I think, is more difficult and more challenging, and I think the research and the practical reality is a lot of people get these in place and they're never revisited. They're there for decades. But people have a different maturation level and there are different levels of decision making. So we can go to the next slide. So again, back into the petition. This is page 4, and it talks about the powers again that the guardian will have, or the rights that the individual will lose, and it's for medical treatment, it's for medical research, it's the power for being experimental treatments. You go down farther, releasing confidential records, the power to make decisions related to mobility and travel. The power to choose medical, social, and supports living services, the agency that works with them. Now, if you look at any one of these, they have a checkbox when you're looking at this power you want to remove from the individual. You check that box, because the standard is if you don't check that box, the person retains that power. So if we take G, for example, and you really can't see that, but I can read it to you. It says the power to make decisions related to mobility and travel. You check that box, that's the power you want to impact through the guardianship process. And then it says choose one or two, and this is true for all of these rights. Is the individual retains limited capacity in the power to, and then there's a short line where you could say see attached, and you could talk a little bit more about what rights they retain in terms of mobility, in terms of travel, and then it says the guardian of that person should exercise the power not retained by the individual. So there you're parsing out what rights that person continues to have and what rights the guardian now has. Or you check box 2, and it's just the individual lacks evaluative capacity in full, the guardian of the person to exercise full power. Just one line, and that's taken away that individual's right to have any say or any input into mobility or travel. And when I think about another example I've used is around financial. If they have the ability, or you give them the right to make decisions for purchases under $300, pick a dollar limit, for example, that can be important to that person, that they can make decisions. They don't have to go to the guardian and say, I want for every purchase, and say, oh, I don't want to, you know, I want to be able to buy this. I have an interest in video games. I mean, you may not care about video games and you may think it's a waste of money, but if it's important to that person, why shouldn't they have the right? And you can set upward limits, and so they don't spend more than, you know, $1,000 a month. You can, my point is, you can take those short little lines. You don't have to cram the whole limits or the process that you're going to use in that. You can just say see attached, and that could have a 2-page framework about how this person, where they can make decisions about their finances and how the guardian's going to be involved, and use that as opposed to just checking box 2 and giving all the power to the guardian. That takes some thought, that takes some time. And again, that's why I'm advocating people start to look at this when their child is 15, 16 years old, and start to think about, is this an area where we want to really clamp down and have full guardianship? Or is this an area where they can have some input? Now, our guardianship statute does talk about least restrictive. It does talk about including the ward in the decision-making process, but human beings, many of them, you know, human nature, many people, if it gets tough, if there's a bit of a crisis, or if there's a short-term need, then you may just make the decision. It's just, you know, more convenient. It's just faster. It's more efficient. You can rationalize it, and I think that can happen. Again, you go down, and the other rights that get taken away are decisions regarding educational and vocational placement, decisions regarding the petition of the termination of marriage, and goes down, protective placement. So this petition, basically through the series of checks, if you just do the main checkbox and check number 2 on all of them, you've effectively taken away all the rights that every one of us takes for granted and we talk about all the time. Well, that's my right. It's protected by the Bill of Rights, and we have a process in our society to take all of those away, and maybe we need to be a little more thoughtful about that. And then again, the guardianship of the estate is on page 6, if you want to go to the next page. Carolyn? Next slide, please.
Yes, George.
Oh, okay.
I did change it. Are you looking for the next one?
Yep. Page. Yep. There we go. Guardianship of the estate, and there's a box there that talks about temporary guardianship. That's more for situations, maybe a mental illness where somebody's having a psychotic break, or they're really crashing and burning and you want to get a temporary guardianship. Again, this form can be used for frail elders if that may be in need of a guardianship. This 7-page form can be used in a number of circumstances. And then we go to the next page. No, didn't have page. Well, page 7 is just basically the signature block. And what the guardianship does, there we go. Yep, is you're just requesting the court, and you just think about it. I mean, some of this is really rather profound in its sparseness, because the request is you filled out that information, you've got the physician's report, you've gone into court, and this is what you're asking the court. I request the court order a hearing on the petition, make appropriate findings and appointments as requested above, and award appropriate fees or costs. So basically, those 3 lines are going to impact an individual's life and their rights for the rest of their life, and that can be 20, 30, 40, 50, 60 years. And it's all incorporated on a 7-page petition. And how much thought do we as a society, we as parents, we as professionals in the schools, helping parents navigate through this? Because it can be very easy to just go through this process, and I know it's relatively, administratively speaking, I'm not saying necessarily emotionally and what it may mean to a family or to the loved one, but it's not a real, in a sense, it can be a very simple, straightforward process that can have a tremendous lifelong impact. Next slide. Here's a little bit about what I was talking about, that the court look at the idea of the least possible restriction on their person's personal liberties, and that's what we're talking about here with guardianship, the personal liberties and their constitutional rights and their integration into the community. So it's in there, and that's what guardians need to do, and that's the other thing that I sometimes will talk with parents about is, yes, you are the parent, you will always be the parent. You have your child's best interests at heart. You have supported them and worked with them up to this point, if we're in the context of guardianship, for the last 18 years. But your role is really a little bit different when you're a guardian. You have to be able to detach and step outside the role of parent and look at the role of guardian. And maybe that's not, you don't need to when your child is 20, 21. It might just be a legitimate continuation of the parental role, and you have the papers to be able to work with school systems and the medical systems and the financial systems. But part of the reason I ask people to consider that is this guardianship is going to be handed off to somebody else. And if it's a full guardianship and you don't work a lot with your loved one about, honoring their choices and just being expedient because in a sense you know best, we're often told through the process that we're the experts on our child. But I don't know about you, but I've had a few instances where I've been blindsided about what my child could do when we've gone into IEPs and asked for support in certain areas, and then to be told that, oh, well, they do that here at school and we didn't do it at home. That's a little it's a little embarrassing, but it can happen. I can't believe I'm the only parent where that has happened to them. But this is really sort of the heart of, if you're going to do a guardianship, that you really need to understand and to be sort of your touchstone about how you apply your powers as a guardian. You make a diligent effort to identify and honor the individual's preferences with respect to choice of place of living, mobility, choice of associates. So it's in our guardianship statute. But the person who does that is the guardian. The court doesn't go back and verify that this is actually happening. So you can go through this process, get your guardianship, and move to your small town, go back to your small town or be in your home in an urban setting and just keep going with this. And again, that guardianship power is going to eventually, for all intents and purposes, going to be transferred to somebody else. Now, it might be a brother of the person with a disability. It might be a cousin. But at some point in time, I would argue that it could be somebody who's not related to that person with a disability. And, what power have you given that person? Because there are corporate guardians. We have them here in our area. Their caseload is full. they're looking for more corporate guardians because the need is there. And if you consider, people with disabilities, with healthcare, people with disabilities, cognitive disabilities, are living longer than they have in the past. And so that means that there could be a guardianship that's utilized by somebody other than you later in your child's life. Next slide. So again, is guardianship the best option? And there's not a lot of research on guardianship, but studies show that only 25 to 50% of families with adults with developmental disabilities make concrete plans for the future. Most adults with a developmental disability live with their parents well into middle age. The transition generally shows up at the death of a parent. And when you talk to regular attorneys that maybe don't practice in this area a lot, it's just standard practice of planning for a person with an intellectual disability, their future. And the guardianship definitely impacts this person's constitutional rights. And the 25 to 50%, the same is true for regular population. And when it comes to making wills and estates, people don't like to think about dying. People don't like to think about not being here. And so they, in a sense, avoid it. But it's going to come. You can't avoid it. And when you have a loved one living with parents well into middle age, and the transition happens at the death of the caregiver, that's a transition in time of crisis. And as an attorney, when people come to my office in times of crisis, you don't make the best plans. You don't generally get the best outcomes because you are in crisis mode. And if you plan, you give some thought to it, you can make transitions have a better outcome. Next slide, please. And again, this is what one study found is, in what shocked me as an attorney. I do motion practice, so I'm in court a fair amount, and I do motion hearings. And when I saw this, that most guardianship hearings last less than 15 minutes, I was stunned. Because when I do a hearing for child support or maybe a custody, by the time you identify yourself to the court, make your appearances, and state the issues, you're well into 15 or 20 minutes of the hearing, just doing the administrative stuff. Yet guardianships are done in 15 to 30 minutes, and this leads me to believe and confirms my suspicion that most of these are full guardianship. Because if you were going to have evidence about the person's ability to maybe make some limited decisions about financials, that would take a little longer. That would take maybe a witness. That would maybe take a report that would have to be entered into the court record. But most of these are done in 15 minutes. And I sit back and I just think they lost all their constitutional rights in 15 minutes. And that those powers got transferred, and those powers are going to be utilized on that person for decades. And that decision and that process took 15 minutes. That gave me significant pause when I came across that. Next slide, please. And why does it matter to reflect on guardianship? It's because the world is changing. And we can talk a little bit more about that. Next slide. Here's some highlights of some changes. There was the Olmstead decision that talked about integrating people with disabilities in the community. And if you're going to be in the community, you want them to be well supported. And the more they're able to identify themselves as a separate individual, that they can, in fact, make some decisions. I think it makes them, in a sense, safer in the community. Where there's CMA final rule that talks about people being being integrated in the community, that should be where the efforts are put in terms of placement, not in institutions, not in maybe facility-based day service programs. We have person-centered planning tools that are out there. We have co-decisions. We have things like circles of support. There are things out there called representation agreements. Now there are programs that a person with a cognitive disability can go to post-secondary education, think college. Those options didn't exist in the world a number of years ago. Attorneys are being trained. I've seen CLEs, continuing legal education, both here in Wisconsin as well as in Minnesota, on supported decision making, trying to train attorneys to help families with supported decision making, and those trainings took place 2 or 3 years ago. So the world's changing. And then there's the supported decision making. The American Bar Association back in 2012 recognized the importance and the value of the concept of supported decision making. Next slide. And now I want to talk a little bit about a real case from Virginia back in around 2013. It was a contested guardianship, because that's something that is also true about a guardianship. A ward can contest it. They can get their own attorney that will push for their rights to fight a guardianship. Now, the other person you may hear about in a guardianship is called guardian ad litem. Their role in the process is to see that the ward's best interests are being served. They are not an advocate for the ward to fight a guardianship. But a guardianship can be contested, and in this instance, a daughter did contest her mother and her stepdad trying to get guardianship for her. So we can go to the next slide. This individual, her name was Jenny Hatch. It's out there in the public sphere. She was 29 years old. She had a diagnosis of Down's syndrome and was categorized as intellectually disabled. And I put this in here, and I'm not a big fan of labels. I'm certainly not a big fan of IQs and that sort of thing, but it's out there, and some people will use it as a frame of reference in terms of people's evaluative capacity, if you will. And it showed here that the respondent, Ms. Hatch, had IQ between 46 and 57, and then was classified as lower extreme and moderately delayed. So if we can go to the next one. And again, the evaluations identified short-term memory as an impairment for the respondent, and what their level of achievement in reading, writing, and math skills was between 2nd and 3rd grade. So this gives you some basis of where society saw this this individual. But they did some work with her, and another doctor evaluated, Dr. Ellis, and he concluded with appropriate supports, respondent would not meet the statutory definition of incapacity, and with supports could manage her property and financial affairs. So this was the debate, whether or not she needed a guardianship. And then you look at when we looked at the previous slide, our society said, oh, this was her IQ, this was her reading ability. And somebody looking at it more closely said, well, with supports, maybe she doesn't meet the guardianship statute definition in Virginia. Next slide, please. So they had a number of witnesses. The parents put on their case, and next slide. The attorney on this, Jonathan Martinez, was the lead attorney for Ms. Hatch, and they brought in some basically world recognized experts on supported decision making, on providing people with cognitive disabilities more rights in society and making guardianships harder to put in place. So she really had a lot of support that many families don't get. I mean, when you talk, I've listened to Attorney Martinez speak a number of times, and he talks about, in a sense, how lucky Ms. Hatch was that she had this drive. She was able to connect with Jonathan Martinez, who knows a lot about this, and she had some outside support, a couple that she worked at their store, and they were willing to provide her with a place to live. So she had a support system other than her mom in place to help her. So she really had a lot of things that lined up for her to be able to go forward and contest this. Next slide, please. And it talks a little bit more about this process, about what the definition, what the factors were in Virginia code, and it's very similar to what's in Wisconsin and other states. Next slide, please. Now here's what the court ordered. It said, it's therefore and decreed that Kelly Morris and James Talbert are hereby appointed as co-guardians for the respondent. Kelly and James were the family, were not the parents, was not the mom and the stepdad. So they were appointed as guardians for Ms. Hatch. So through all this process, she was appointed, she had co-guardians appointed for her. So she did, even though she fought it, she got the guardianship appointed to her. But there's more to the case. So next slide. And this, we have a little bit of a peek at the future with this case. Go ahead. They were appointed as co-guardians, but it was a limited guardianship of limited power and limited duration, with the ultimate goal of transitioning to the supported decision-making model. So the judge had to be educated on this process, and he found that yes, in the short term, she needed a guardianship, but the guardianship she was going to have was going to be limited in terms of its scope, and it was going to be limited in terms of its duration. And then they were to come back after a year and evaluate whether or not the limited guardianship should continue, or in fact the supports were put in place so that she could go forward with a supported decision-making process and not a guardianship, and the guardianship would be removed, would be terminated, and she would not be going forward declared incompetent. So this was a very, it wasn't a passive order. It was an order that really put the onus on Ms. Hatch as well as the guardians to work on her decision making, work on putting something in place so that when they came back, it could be evaluated. Again, she's being watched. She has support in place. They're keeping her safe. They want to see that she isn't exploited, but it wasn't something that was just put in place and set forth for the next 10, 20, 30, 40, 50 years to operate. Let's go to the next slide. So there it talks about guardianship expires in 1 year, and they did talk about the powers to make medical and safety decisions, and talked about deferences to the wishes of the respondent. So making it very, very specific and making it very detailed about what it is Ms. Hatch could and could not do, and the fact that this wasn't something that was going to necessarily be in place for the rest of her life. Next page. A little bit more about what the guardians needed to do, helping her understand financial issues, all the things that if you recall from the petition, were powers that can get checked or limited. Next slide. So a resource for you is something called the Jenny Hatch Project. If you click on that or go to that website, talks a lot about what she's done. She's gone on to advocate the restriction of guardianships. And Jonathan Martinez is also involved, and he's really not a national expert on this and the power of somebody maintaining some of their independence. You go into some of these links. There's research. This is evidence-based. They're finding that people who don't lose their rights, who keep some of their rights, they have a better sense of self, so they're able to protect themselves and identify as an individual and be able to say no. If you think about it, when we go through the education process, one of the things we always want, we hope when our child's having therapy that they're compliant so they get the benefit of the therapy. Lots of strangers come in and poke and prod and test them. So, we identify, this is the doctor or this is the therapist, and they're complete strangers, and they come in and they can be very accepting. But as an adult, they maybe want them to have a better sense of self, the ability to maybe question and say no, or identify that they don't have to always be compliant. And then the other resource is the GWAR, which is the Greater Wisconsin Agency on Aging and Resource Centers. They have a whole section in their organization, at their agency, that deals with guardianship. So that's another place where you can get resources to educate yourself and to look at what it is that you want to do with a guardianship and what your hopes are for your loved one in the future. Next slide. And so what we just got signed on April 16th, not even a month ago, was Chapter 52, which is supported decision-making. Wisconsin is one of 3 states with a supported decision-making law, and it's designed to assist people wanting to use the supported decision-making process in their lives. So now there's something else statutorily recognized in the state of Wisconsin to help a person with a cognitive disability to manage their affairs other than a guardianship. Next slide. And there are other alternatives even than guardianship, and the next presenters, Russell and Beth, are going to let you know what those are. Hopefully I've been informative, giving you some food for thought. Again, I'm not saying that guardianship is not appropriate. I'm just saying we need, as a society, we need to look at this. As the legal profession, we need to look at this. Educators, I think, need to look at this, and most certainly families need to look at this in a more deliberate way. And I understand how it happens, because I try to get out and talk about these issues more. And I've had people where they want to do supported decision making, but they get overwhelmed. The systems are, and I've experienced it because we do not have guardianship. We have been using the supported decision making process now for 2 years, and it's not necessarily easy because you run into some systems and they look at you, and there's an expectation when someone has a cognitive disability that you have a guardianship, and they want to see your guardianship papers, or they start talking to you, and I say, I'm not his guardian. You need to talk to him. I'm here to support him. What releases do you need signed? So I understand the pressures to where it could be, it just might be easier. So thank you for listening, and enjoy the rest of the presentation.
Okay, thank you very much, George. That was very informative. And as George had said, Beth and Russell are going to continue on with this information regarding especially the supported decision-making options. We'll just move on to the PowerPoint that Beth and Russell are going to be utilizing during their presentation. It begins with building a full life using supported decision making. So Beth and Russell, I will turn this over to you, and I will advance the slides as you'd like me to, unless you would like to do that yourself.
All right, good morning, everyone. And again, thank you, George, for that really great overview of guardianship. Russell, McCullough, and I are going to be speaking to you about alternatives to guardianship and in particular supported decision-making. Like Caroline said, I am a project coordinator at the Board for People with Developmental Disabilities, and I also work with Wisconsin Promise.
And I'm Russell McCullough, and I work for Wisconsin Board for People with Developmental Disabilities.
All right. So today I wanted to just kind of let you know that we will have a few videos included in our presentation. And I also just recently participated in a presentation from Montana. So I have a few more resources that I wanted to share with you. And I actually learned about those after I had sent in this presentation. So I'll try to give you that information as slowly as possible. So if you want to write it down, you can. Okay, next slide. All right, so I'm going to be speaking to you primarily from the perspective of a parent. I have a son who is 25, and he has a developmental disability, he has autism. He actually lives out of state, and so we are extremely grateful pretty much every day that we do not have guardianship for him, because he is able to make a lot of decisions for himself. It would be very, very difficult for him to be living out of state if we were his guardians. And also, I will say that when he was 17, we did not ever think that he could possibly be moving out of state away from us. It was kind of a far cry for us to think about him moving out of our home. So we are extremely proud of him and happy to support him. He has developed a circle of support in his new home. And so I really do feel that, you know, I'm speaking from the perspective of someone who did not choose guardianship. And I did that with the help because the decision would be life-changing, and so we decided to just sit back and wait for that. So we wish for all of our children happiness, good health, friendships, love, to be respected, to celebrate his or her uniqueness, and also to be safe and secure. You know, this is something that we wish for our children who have disabilities, and also for our other children. And I think as parents, one of the things we ask ourselves all the time is, how do I best support my child? What is my role in his or her life? Is it my role to make decisions for my child, or is it to teach and empower my child to help them make their own decisions as they grow into adulthood? So we're going to be talking today about supported decision making. Very excited that we're going to let you talk about the new law that's in place now, that people will have a legal document starting now. This definition of supported decision making is from the National Resource Center for Supported Decision Making. Jonathan Martinez, who was the attorney in the Ginny Hatch project that George referenced, he reversed guardianship in that case, and he also advised the Wisconsin WINGS group. WINGS stands for Working Interdisciplinary Network of Guardianship Stakeholders. This group was made up of judges, medical doctors, attorneys, self-advocates, and advocates. They all have been working together for a couple of years to put together ideas for Wisconsin that has actually led to that new legislation. So this, I'm not going to read you this slide. You can see, though, that supported decision-making is a set of strategies that help individuals with disabilities have more control over their life and future. Okay, next. And supported decision-making is also a recognized alternative to guardianship, through which people with disabilities use friends, family members, and professionals to help them understand the situations and choices they face, so they may make their own decisions without the need for a guardian. Supported decision-making, if you already do have guardianship, can also be very effectively used within a guardianship. So please, don't turn off just because you already have guardianship. Supported decision-making really gives you some great ideas and strategies for empowering your child or your ward to help them to, as George talked about a lot, mature as they get older, and help them to learn to make those decisions, important decisions in their life themselves, with the help of a circle of support. Okay, I'm not going to talk very much about guardianship because George has pretty much covered everything. I think that I would prefer to go ahead and talk more about supported decision-making. I do want to just reiterate that guardianship should only be used in emergency situations when a person is incapacitated, and to support people who need immediate protection from exploitation or abuse. And I think that you can go to that website for GWAR that George referenced, the Greater Wisconsin Agency on Aging Resources. There is actually a really great training on that website for those who have guardianship. And I do know people who are guardians for their children, and they looked at that training and they said, I never knew that that was my role as a guardian. I just thought I was going to continue being my child's parent. I really had no idea. So I think if you are considering guardianship, to go to that GWAR, Greater Wisconsin Agency on Aging Resources, take a look at their training for guardians, and you can get some valuable information there. Okay, now we're going to watch a video. This is about 8 minutes long. It's kind of long, however, I think you'll find it to be really informative. This is a video that shows different families talking about their decision to use supported decision-making with their child, or their wish that they had used supported decisioning and not gone through the guardianship process. And many of these individuals have significant disabilities.
What is supported decision-making, you ask?
Supported decision-making is a way people with disabilities, both physical and intellectual, can make their own decisions and stay in charge of their lives while they do so. Throughout this video, you will meet individuals who make decisions every day with different levels of support. As you will see, many parents are advised to seek guardianship for their children when they reach the age of majority. Supported decision-making is one option on a continuum of decision-making options that enables people to gain support from important people in their lives to make informed choices.
I am a single father of a Down syndrome 22-year-old daughter.
Christopher has cerebral palsy. He's also considered deafblind. He is completely dependent on others to care for him.
My mom had a stroke in 2002, and on top of that, she had dementia.
My name is Tara Buster. I'm 34 years old, living with my mother. A few months after graduating high school, I was in a car accident and suffered a severe traumatic brain injury.
Bridget was born 5 weeks premature and had some issues at delivery, lack of oxygen. So she ended up with cerebral palsy.
At 18, since Anne was still in a coma after her accident, her parents chose to hold power of attorney rather than becoming her legal guardian.
I have self-advocacy. I don't have no legal guardian.
I went to a lawyer and he had told me she's not able to give permission, so we had to go to another route, and that's why I ended up going to guardianship.
I have guardianship of Bridget, which I regret. At the age of 18 in school, I was told that if Bridget didn't get guardianship and something happened to her and there was an accident or she needed surgery, I wouldn't be able to sign for her care and that she could die. That was totally untrue. But as a mother, thinking that I was doing the best that I should be doing for my daughter, my husband and I went ahead and got guardianship. Not knowing that there are other choices such as healthcare, power of attorney, and supported decision making, which is new.
Supported decision making means to me making decisions with the support of those close to me.
Support decision making, as far as is within the realm of my household, says that as a family, there are certain decisions that, because of her disability, she's not going to be capable, mentally capable of digesting the seriousness of it. So at that point, those are the times when I intervene.
In my situation, having personal assistance makes independence possible for me.
For our families, I think we want Christopher to always be home. So therefore, we need to make sure that we're addressing any new things that come up as he's getting older and as he needs more equipment. We need to be prepared to be able to find the way, to find the resources so that Christopher does have those supports in the home.
It's a good thing because you got different options for somebody can reach out and help you.
I may not think she can do it, but pass or fail, we will try, because this is what, support is. Support is not making decisions for that person. It's to help that person, guide them in the direction that they want to go.
And she'll always have someone looking after her, but she doesn't always need someone telling her what to do.
She was there for me, so I should be there for her on her behalf.
I don't think that supported decision making is something that someone should have a dominance over someone this capable of doing, just because they are titled with developmental delay.
I make decisions to work every day. I do make dinner every night. I watch TV. I get my drink Dunkin' Donuts. And I do groceries.
Everything we've done so far, we always have done it thinking in his quality of life. That the choices that we are making is going to give him a better quality of life. Not what I want as a mom.
We protect our children because we think they're going to make mistakes and they're going to get hurt. We're not giving people with disabilities the opportunities to learn from their failures.
The biggest decision was, removing selfishness out of it. Because when you're a parent with a special needs child, you go through a lot of different things, put yourself on a lot of different islands. So it's easy for you to say that you're making the best judgment for her, even though it's just for yourself. So to be able to critique yourself and say this is really what she wants to do.
So there are little things in life that have taught me through the years, along with Bridget teaching me, that she doesn't always need me around. She needs the support of the community and her family.
I want to be the one in the driver's seat of my own life. And if that means taking some reminders or hearing some suggestions from time to time, I'm all for it.
Christopher's life matters a lot to everybody, that from taking care of Christopher to getting to know Christopher out in the community, he's very important. And people need to see him as an important citizen and that his life matters.
I would like people in the non-disabled community, I would also like policymakers to know that Bridget has options, and for people to know to give people their options. We need to educate people on what there is out there. And I want Bridget to just be like everyone else.
I'm independent. I make my own decisions.
Freedom of choice is a civil right given to us by the Constitution of the United States of America. Supported decision making allows us to make choices and have a self-directed life. Everyone has the right to make decisions, even if one needs a little support.
Your support, my decisions, endless opportunities. My life.
All right. I think that video is very impactful because you see how several different families have made the choice and how they use supported decision making. One of the things that they talked about was that the freedom of choice is a civil right. And we're going to talk a lot about choice, about making choices, and about how families who have children with disabilities need to be more mindful about teaching their children to make choices. And also we need to be speaking with the schools about giving our children choices, because that's how they're going to actually mature and learn as they get older to be able to make decisions. You know, I know that I ask a lot of advice. I use Google all the time, numerous times during the day, to ask questions, how to do something. I think most of us don't just sit down and fill out our tax forms. We maybe go online, we get instructions, or we take our taxes to an expert. Medical care, very, very few of us treat ourselves if we're ill or if we have an injury. Auto repairs, not that many people I know fix their own cars. So we all ask for support. And I think that it's just part of our daily life, and so we really don't think about it that much. But if it's your child who has a disability, then we often feel like if they are asking for support or if they're asking for help, it means that they aren't able to do something. We really don't give them that option to ask for help. We don't teach them to ask for help. And I think, too, that one of the things I heard when my son was really small was that we should be giving him the freedom to fail. And I was horrified by that idea. I thought, I don't want my son to fail. But when you think about it, if you're not given the freedom to fail, then you're really not ever going to be learning how to make decisions. All fail at something. And if we have somebody there to catch us, which is what we do as parents and as family members, we catch that person, provide that safety net for them, so that if they do make a wrong decision or if they do fail, then we're there to catch them and to make sure that they've learned something. So next slide. So again, I just want to, kind of continue to talk about the idea that we don't all make the right decisions all the time. We don't all make the right choices, whether it be we get lost when we're driving, whether it be that we are late for something, we might make a turn when we're driving and we end up in this construction that we knew was there, or we might walk outside and not actually know that it's raining and we don't have an umbrella. Does that mean that somebody else needs to tell us what to do as we walk out the door? Absolutely not. We've learned that tomorrow we probably should look at the weather and see if we should take our umbrella. It's absolutely okay to make wrong choices and to make decisions that are not correct, because most of the time we're going to be learning from those. Okay, next slide. So this is a slide I really like, and I'm just going to keep talking about this because I know that I had to be told this or talked a lot to about this when my son was young. What are my fears? My fears are that he's going to fail, that he's going to get hurt, that he's not going to be safe, something bad's going to happen to him. But really, as parents, our job is to push push the baby bird out of the nest. And I always look at that photograph of that little baby bird, and I guarantee you that the next photo, the little bird's going to be flapping its wings. That mama is not going to push her baby bird out of the nest if she doesn't think the baby bird's going to flap its wings. As far as the other two, the kangaroo, she wants to keep her baby in her pouch as long as possible. Same as us human parents. Our instinct is to keep our children close, but we do need to remember that our children need to learn maturity. That's our job. Our role is to help them to be independent, independent humans who are contributing, who are happy, who are secure. So next. And so even the research shows that people with disabilities who exercise more control over their lives are healthier, more independent, better employed, better able to avoid and resist abuse. I think this really is common sense, but I'm telling you that there are research, there are articles that you can read that, that show that evidence. Okay, next. And one of the things that we also talk about, when we're talking about people with disabilities and their ability and learning to make decisions, is self-determination. In fact, the agency where I work, the Board for People with Developmental Disabilities, we have a huge conference every October that I recommend that all of you sign up for. It's one of the largest gatherings of people with disabilities in the country. You can go to the Board for People with Developmental Disabilities website and get information about that conference. It is an amazing opportunity for people with disabilities, their families, people who care about them to come together and talk about how can we make opportunities available to people with disabilities to live a full life, to live that life of employment, independent living, happiness, and fulfillment. So next. And when people are denied self-determination, they feel helpless, hopeless, and self-critical. They experience low self-esteem, passivity, and feelings of inadequacy and incompetency. That's another, more research. It's not just things that we already know as parents. Having choices is important. This link at the bottom of the page is it's for a full curriculum from the Weisman Center. It's been around for a while, but it's a great kind of packet of activities, materials that families can use starting from a very young age to help teach their children to make choices. Oh, there it is. So this is a really great curriculum to share with the school, to use at home. You know, I really wish that I had had this because when my son was young, because it kind of gives us as parents some structure about teaching our children how to make choices. And that's really where it all starts, is when they're very small, giving them options at home, teaching them to make choices, maybe in what they wear during the day, maybe what they eat, just those kind of basic choices that are really going to help that child to develop the ability to make decisions. Okay, the next slide is for another video. And this one is about a woman named Gabby. She lives in San Francisco, and she has a physical disability. She talks about her circle of support that helped her to make a life-changing decision in her health care.
was born a bifida. I've had to deal with a lot of surgeries that has to do with it. Having to decide myself, it was really hard. But now that I have a lot of people that help decisions, it's a lot easier on me.
For the longest time, and still today, people with disabilities were thought to not have the ability to direct their own lives.
There is an assumption that a person with a disability is a perpetual child, and guardianship or conservatorship makes that assumption a legal reality.
We essentially take away the legal status of an individual. We say this person is incapable of making decisions themselves, and so we are going to appoint someone else to make the decision for them.
Most people with disabilities are able to make their own decisions, and there's no reason why we should be taking that autonomy away.
Now there's a newer concept, supported decision making, that says people can make their own informed choices. They may need support to do so, but offer that support so that everyone can have independence. Supported decision making to me is really exciting because I think we're talking about people taking their own personal health.
Good morning.
Good morning.
How are you? Fine, thank you.
Gabby's team consists of Gabby and her mom as the sort of central nucleus, and then Mark, who is the health advocate from the ARC, and then care provider.
Tell me what's been happening in the past couple months.
We talk about what's going on, and we finally make a decision together.
All of us tap into expert decisions in our lives. We consult lawyers and people who are more knowledgeable than ourselves to help us make decisions. Supported decision making is no different than that.
Hello, Gabby, how are you?
This year has been particularly tough. Gabby was hospitalized for many months, required several surgeries. The decision making around this was to help see what the benefit of having these procedures done and what was the risk, and also trying to focus on kind of the light at the end of the tunnel.
I was so scared of having eye surgery when the doctor had said that there was a 50-50 chance that it would get better, or as the time passed, it would get worse. At that instant, I just shut down because I did not want to lose my eyesight.
Talking about risks to the surgery, benefits, at the beginning, she was only thinking about the dangers of it.
We finally came to a decision just talking about it. I am so happy that I did decide to have my surgery. Before, I would see double and I would have blurry vision. And ever since the surgery, none of it has happened.
Okay, we'll probably have to ask you to watch the remainder of that video as you have time, and we'll go back to the presentation.
Yeah, it was almost finished. I think we got pretty much the most important part out of that she made a decision to have very invasive surgery using a team of people around her to help her vision. That's really what we hope for our children. That's what supported decision making is all about. It takes, the parent is still a part of that decision making process, but there are all these other people around the individual with a disability to help them come to that. You know, we as parents are not experts on everything either, and so really we shouldn't be taking on the responsibility of determining the decisions that are made on behalf of our son or daughter. Okay, next. Okay, now we're going to go to our story part of our presentation. And Russell will be joining us in a few minutes. He's going to talk about his life and how he uses supported decision making as well. We're first going to talk about a few people that we have presented with before, given us permission to use their stories. They're very happy for us to kind of talk about how they live their life and the strides that they've made. They also, this group of people are the People First Board, the Wisconsin People First Board. If you're not familiar with People First, it is a group, a statewide group that is for advocates and run by self-advocates. They are based in Milwaukee. They do have an executive director who is based in Milwaukee, but there are group kind of satellite People First groups all over the state. The people we're going to talk about are actually on the board, and I just found out that the board of Wisconsin People First has been invited to Alabama to speak at a conference about supported working. So that's really exciting. We are really in Wisconsin at the forefront. We've got a lot of people who are really passionate about this idea of supported decision making. Wisconsin does have a very high rate of guardianship, and so we feel like there are a lot of people out there who we'd like to share this information with. So Marie is one of the People First board members. She has her circle of support consists of her family. She has a couple of siblings and both parents. She told me that her parents always encouraged her to make decisions. They gave her that freedom to fail, and that they were really insistent upon working with her to solve problems. They really didn't make a lot of decisions for her as she was growing up. And this kind of ability of Marie's to make her own decisions and also her willingness to get out into the community has resulted in a really full life. She has her People First friends. She has an advisor who is also her representative payee. And then she also mentioned her pet cat as a great support and comfort for her. Next. Marie also, once she got out on her own, discovered that she has this interest that none of her family members share. She absolutely loves going to tractor shows where she's met a lot of people where she shares a common interest with, and also buck skinners. And this is something that, like I said, her family didn't know anything. So this didn't come from them. This came from Marie going out on her own and meeting people and finding this passion. So Marie, when she moved out, she did get, she said that actually her supporters kind of encouraged her to move out, and she wasn't quite so sure about the idea. But she said that eventually she came around, and because they all knew that she could do it, and they really encouraged her. And now she lives in her own apartment, and she loves going to the tractor shows, the mountain and buck skinners reenactments of the 1800s. She also tells the story of the first night in her new apartment. She actually burned a pizza in the oven, and the fire department had to come, which I think is something that probably it didn't happen to her because she has a disability. It happened to her because she was a young person living in her first apartment, wanting to make a pizza, and she just happened to forget about it, which has happened to an awful lot of other people. So I think that, you know, when you see the people from People First, you might be thinking, oh, I don't know, my child, there's no way they're ever going to be that independent. I can't see that in their future. But your child is really only maybe 14, 15, 16, 17. Right now, they are still a child. They are going to change tremendously. My son actually grew 2 inches this year. So he's 25 years old and he grew 2 inches. So he is really changing, not only physically, but also mentally. So, you know, if your child is approaching 17, I really encourage you to take a deep breath. There are several different options that you can look into without jumping into guardianship that are not nearly as restrictive. And there is always, if after 5, 6, 7 years you still feel that guardianship is the right option, then you can always do guardianship later. There is no law that says that guardianship has to happen at age 18, regardless of what people may tell you. Okay. We do have the Board for People with Developmental Disabilities has this resource on our website. So if you do the BPDD website, you can find this booklet. If you click on it, you can go page to page, and we do have links to lots of different resources in Wisconsin. You can find links to the power of attorney document, to information about representative payee on the Social Security website, information about special needs trusts, information about healthcare power of attorney, IEP, the waivers that you, not waivers, sorry, the releases that you sign, that your child can sign in an IEP meeting so that you can continue to participate. HIPAA waivers that the child can sign so that you can go to the doctor's appointments with them. So all of this is in this resource. So I really encourage you to go to our website and check that out. Okay. So George did talk about the new law, and I do have to apologize. This law is so new that we have just now got the finalized version of the supported decision-making agreement on our website. It no longer says sample on it. So you can go to our website, you can download the supported decision-making agreement. It is legally binding now that we have the law in place. Okay. So a few guardianship alternatives. I am not an attorney, and I am not fully, I'm not at all in a place to be able to advise you about what you should do with your own family situation, but there are numerous alternatives to guardianship. You can actually go to that GWAR website that we talked about earlier and find more information about alternatives. As you can see, there's a whole list of them, of various different levels of support. For example, the power of attorney, financial power of attorney is something that you can download from the internet, get a witness to sign it, and that will give, it's pretty, it gives pretty broad ability for the person who has power of attorney to control and to make decisions, financial decisions. The Special Needs Trust allows the person with a disability to save money so that their Social Security benefits are not affected. Going to the medical, the signed HIPAA release form, you know, a lot of us do that anyway. I know if we have aging parents, a lot of us will have those release forms signed already from our parents. That's something that's very easy to do at the doctor's office. Living will, everyone should have a living will. If you have a disability or not. Power of attorney is another one that everyone should definitely have. And then those IEP meetings, there is a release form that your child can sign that will give parents the ability to attend the meetings and receive and see all of their records. Okay, so next. So again, this is according to our national core indicators from 2013-14. Research shows that people with intellectual and or developmental disabilities who do not have a guardian are more likely to have a paid job, live independently, have friends other than staff or family, go on dates and socialize in the community, and practice the religion of their choice. So it is really important that before you make the decision to take out guardianship, to consider all of the options. All right, so this is our BPDD website, and with the supported decision making, I'm not sure if this is actually the pamphlet, so there you go, there it is right there, and you can download the supported decision making guide, and as I was talking about earlier, you can go page to page and you can find links to all of those to guardianship.
We can pop back to that.
Yeah, that's fine. And that's, there's so much there. I would really encourage you all to take a look at that. So now it is time to hear from Russell McCullough. We're going to spend our last part of our presentation hearing Russell's really wonderful story of his full life and how he uses supported decision making to make important decisions in his life.
I'm Russell McCullough, so I'm here to talk about my friends and my story, basically my long-term going story. So I'm going to talk about friends, apartments, work, and living my life. So, next slide. Oh, sorry. I'm sorry.
Could you tell us about the photographs, Russell?
Yep. I forgot to mention the photo. Sorry, I didn't think I had. The first one up in the right-hand corner, it's my picture. That's my interview. I applied for this job, on which I was age 20. So I interviewed in January. I didn't get hired until like the 20th of February. That's when I started here in 2012. And then the picture on the left-hand corner, that's me. It's, most of them, they no longer here anymore, but there are new ones. But those are people I had since when I first started here, but that's a picture of me with an award at the podium at my high school. And the picture on your right, that's me. I would say we all have our own cubicles, and that's our old building when I was used to have to work at an old place, but still same the company. But we moved here in 2013.
Could you tell us about high school and transition?
After high school, I graduated. After high school, I went to Project Church 2010. So it's Project Church is mainly for people with disabilities. It's a program. It's like an intern program that helps people learn job skills and what they're gonna do out in the community, how the work life's gonna be. And also, I did have vocational teachers, several of them. I had 2 of them, but I worked with at the Project Church program is Marsha. Marsha was my supporter and my teacher at Project Church. So
tell us where did you go to high school?
I went to high school, about high school.
And did you have anyone there who was a great help to you?
Yep, I had Nancy Grace. She was my vocational teacher, and she also was like the person I go to most of the time when I need things. And she also helped me, got me into Project Church of this program, and then that's where I started my journey from there, getting learning all sorts of skills, and then I had 3 departments. First department, I worked in D clinic in the VA hospital. I think usually each department they have you work there for 3 months, from what I remember. And then after that, I went down to a meal laundry service. Went down to a laundry service in VA. Did that for in the summer, and then by fall, and I transitioned to the mailroom in the VW hospital, which that's where that got me an idea what did I like the most out of it. Just doing clerical work and stuff like that. So, and then the picture right here, as you see, it's me, a picture with me in a limo with a friend, but they had a wedding of some sort there over at Chemical Gardens. So, and that limo there was my first limo I had for my 21st birthday.
So Russell, I have one question about while you were at Project Search. So who helped you figure out what you wanted to do when you finished at Project Search?
Marsha got me into this job, and she offered this job to me, and I said I was very interested because, I knew it would be a good fit for me.
So do you feel like Marsha and Nancy were good supporters for you during high school?
Very much so. And at work, I'm going to talk about my work situation. So like I said, I started here in 2012. And I worked at BPDD and Fleet for at least good first 3-4 years before I got another job. But I'm going to talk about Natasha is my office manager and is my supporter outside of work and at work. And she's like a job coach friend, and then like a sister, she looks out for me. But I hired her through the county I paid her through the county to be a job coach, to be here instead of having other job coach and disrupt you at work, which I kind of find it more, which I find this way more easier. That way you don't have to worry about anyone popping in or, but the picture on the left, I made a card for her on Boss's Day a couple of years ago. I got her a CD and cool looking. And then the picture to your right, Natasha and I went voting for her first time, so we voted together, and she took me to vote, and she helped me learn a little bit more about voting, a little bit, and how it's like, what you should do and stuff.
So Russell, one question: do you have a guardian?
No, I'm legal. I'm my own legal guardian.
So tell us, Russell, it sounds like you do use supported decision making. You've got Natasha, Nancy, you've had over the years Nancy and Marsha. So who do you talk to? You go for help for financial questions and decisions?
I mainly go to my rep AE. She's my rep AE of fiscal assistance. But that's the main person I go to for financial questions. But then health concern questions, I mainly talk to my doctor, or I call her once in a while. I ask me a question about something, and that way it just kind of helps me get an idea, or just helps you learn as you learn. It helps you learn as you grow and learn on your own. And sometimes if you're just curious about things, if you have a question or concern, it's always good to call and ask that.
Are there other people, and who would they be if you had an emergency, like health problem? Do you have other people that you could go to help you call the doctor?
Yeah, I mean, I have my sister, I have Natasha, and a couple other good people I have in mind too. So.
Okay, great.
So I've been pretty fortunate. I don't have to do that.
So you've been pretty healthy, huh?
So far.
Good. Good. All right. What about your social social life. If you're having an issue with a friend or somebody puts something on social media that you think is inappropriate, who would you talk to about that?
I mean, Natasha, I would probably talk to her mainly about it, because she and I have a lot in common and about a lot of different things, and so I also, talk to my sister sometimes too about stuff, and she doesn't like how people do certain things in ways too, but
The family too, right? Did you know? What about can you tell us about the family?
Well, it's on the slide too, so
okay.
I'll explain a little more about that as we get to the next slide.
Okay, sounds good. All right, tell us about your jobs.
As soon as I'm here, as you see, I have 4 jobs, but my 2012 up until now, so I work 4 jobs, 21 hours a week. Monday is the same as I work at Zenith Limousine for 2 hours, maybe 2.5 hours mostly, at least. They've been more accommodating now, letting me work 2.5 hours now, since there's a lot to do there, which is pretty nice. They're pretty flexible. But then Tuesday through Fridays, I work here, and then I work at Fleet for 2 hours each job. And I don't really work at Saturdays at MSCR anymore, because my hours and schedules got kind of switched around. I was kind of off for a while because during the winter time they didn't have enough participants to do the actual city clubs, so that's why. So I'm going to be doing that in the summertime, doing assisting with kickball.
So Russell, when you've told people about this, I've heard them say, how do you keep track of your schedule? So busy.
Well, I mean, my phone has a shift planner app where you have like a work schedule sort of thing, or it's like it tells you when your next shift is. But then I mainly keep it all in my head. I've been pretty good about like stuff like that, but sometimes I put stuff down on Outlook at work, or like important days like conferences or any other important days, like if we have to go like away somewhere to speak somewhere, or like I usually do pretty good remembering everything. Most of 98% of the time I do well knowing, I can't do this. But these 3 pictures right here, they're all from DC, Johnny Shaw. I went with Beth Moss and Lisa Peel. And the first picture on top of there, I believe that's the capital of DC. But then the second picture to your left, that's a picture of the White House in the background. And then the third picture on your right is me and Beth Moss with Washington Monument.
Right. So tell us about moving out of your childhood home. And you can just tell us kind of what happened. You don't really need to talk about before that. How about that?
Moving out was hard, that's all I can say. But Julia was my former broker I had for almost 5 or 6 years. All through middle school I think I started her in middle school, I believe. But then I had her up through beginning of middle school up until 2014, and I moved out at age 23, and she helped me find a place for like an emergency situation. So she just like quickly like found the place, and so Julia was my broker, and she was my supporter. She also helped me find like extra clothes and furniture. And Stephen was the main person that I first met through Integrity Residential Agencies. I think I met him in 2013. And helped me supporting living was my supporter, and we hanged out in the community like once or twice a week. Just kind of get a feel of things, how things are in there. Just kind of get a feel like what out and about by yourself and or with somebody, or so. And then from 2014 up to 2016, I lived with roommates. I lived on my own. Wanted to be on my own, but it took a little bit of time to build up skills, what you need to do, and so And Joey also helped me fill out an application for this current apartment I have now, which I've been there for 2 years. So I moved out in April 1st, 2016 into an apartment. So next slide, I'll talk a little bit about my friends and family and supporters. This first picture right here on to your left, that's me and my long-term friend. They also are considered more like family to me because they've been around for almost 20 years for me. That's my, his name is Eric, and Eric and I, we seem to do a lot together, and we do things a lot, and that's him sitting right with the red shirt. That's who I'm talking about. And then the second picture, middle center picture, I have my 25th golden birthday party. We saw it at Rocky's Rococo Pizzeria on the east side off of East Ross by Surrey Road. I rented an 18-pass Hummer, so for my birthday. So it's only 2 hours, but they're really expensive, but it was worth it.
How did you all pay for the Hummer limo?
We all pitched in money. The good thing about it, the driver ended up kind of paid a little too much money. We all kind of did, so the driver ended up having some $75 worth of tip. Yeah, and Eric's mom was like, "Oh, next time I think we shouldn't really give him too much like that." But I mean, I was like, "Well, I mean, he did a good job, so he was really nice. He deserved it, I think." They're professional drivers. They learn to be good at that's what professional chauffeurs are. They're good to be prompt and polite and on time and respectful. But then the picture on your right-hand corner, I hosted my own Christmas Eve party later that year, 2016. So the person behind me, that's my former roommate I lived with for 2 years, but then the friend behind me, that's another good friend I known through high school. His name is Malcolm. The second person behind me, his name is Justin. Next slide. And then that's me and my friend and his girlfriend. We used to do bowling on Saturdays with his mom, or either Friday nights or Saturday nights with his mom. So, and then we were having pizza and all that, and his girlfriend happened to come with us, so we all hanged out and we bowled together. And that, as you say, that's his girlfriend right there, the one in the red. But then the picture on your right-hand corner, that's me, Malcolm, with the limo selfie there. I think that's probably one of the best selfies I've ever gotten. So I think somebody else took that picture for me. That really helped him better. So next slide.
Hold on 1 second. So Russell, is there anything else that you would like to share with people who are out there listening about how you make decisions or what you'd like to in your future?
Well, the nice thing about it, you can always set your own goals, plan out your future. You know, like it's always nice to do future planning, right? You know, figure out what you want to do, what you want to achieve, and then the next few years, like one of them is to achieve my driving skills.
Right. So you'd like to get your driver's license?
Eventually down the road. I'm hoping I'll be driving in 2 years. But
who do you think is going to be helping you to get your driver's license?
We've got a couple of people on Natasha's dad is one of them.
Yeah.
And then Eric's dad also offered to help me once I do get my permit and all that. So I got a couple of good people. You know, I think my next door neighbor, he also mentioned too that he offered me to drive this old small truck that I already told him, well, I got already a couple of people in line that might possibly help, but it's possible.
So you've had a lot of people step up and volunteer and offer to help.
Yeah.
That's great.
Sorry about that. I'm not trying to be noisy.
That's fine. All right. Well, thank you so much, Russell.
You're very welcome.
Yeah. Good to hear.
I tried to do my best like I did the last week at the conference. So.
Yes. Yep. Yeah. Russell's done a great job presenting to a lot of people all over the state, and so I have some of those same questions that generally people have, but I'm hoping that people will. We're going to wait at 11:30. People will be sending in questions for us, so you may have some questions from the audience. All right. Okay. Well, I can continue talking a little bit about getting you some more stories from Wisconsin, as well as some tools that the Board for People with Developmental Disabilities has come up with to kind of assist with that, teaching both parents and youth supported decision making. So Josh is another member of the People First Board. Josh's mom actually does have guardianship, but within the guardianship, they use supported decision making. Josh does a lot of traveling with his People First group, going to Packer games. He loves sports. He loves going fishing. His mom and he live in the same town, but Josh actually lives on his own with a roommate. You can click. Lives on his own with a roommate. He has a staff person, the broker, who helps him to navigate the employment and residential services. But he also has a lot of friends that he hangs out with in his town. Yeah, so Josh, like I said, he has a roommate that he gets along really well with. He works at a nursing and rehabilitation center. He volunteers at his church. He loves going bowling, camping, watching movies, loves Bucky, and he likes to hang out with friends. So as you can see, Josh has a really full life. His mom gives him a lot of freedom, and if there is a decision, they talk about it, and his mom gives him guidance. She doesn't make decisions for him. And he uses all of that group of people living in his town to kind of bolster him up and help him to make decisions. Okay. So Cindy is actually the executive director of People First. She lives in Milwaukee. Cindy has a very interesting life story. She actually started out in foster care and then lived in a residential facility in an institution. And she had a guardian as a young person who was very enlightened. And her guardian actually decided with Cindy that she was ready to be out on her own and that she actually didn't need guardianship anymore. So this is kind of, I think, a story of a very positive outcome for a young person who has a guardian as a child. They went to court, and the guardian assisted Cindy in becoming an emancipated adult. So next. So Cindy has a very large circle of support. She knows people all over the state. She's made quite an impact. She's traveled as a Special Olympics ambassador. She has written a book. She has met with numerous dignitaries. She's given speeches in Washington and all over the country. She's all parents were actually her foster parents, and have a guardian. But her foster parents did, when Ginger turned 18, they actually adopted her so that she could take their last name. but they did not take guardianship. So they have had a very respectful relationship, very typical parent-child relationship, and now Ginger has the same last name as her parents. And Ginger is, okay, next. She's a really involved in her community. She was part of the committee to raise money and build the accessible playground in Oshkosh, which is the largest accessible playground in the state. She is an advocate, a big advocate for other people with disabilities. She's won awards. Like I said, she's on the People First board. So she has an incredibly full life. She has a boss who she works at a financial advisor's office. So her boss is her natural financial advisor. She has her People First friends as her social network, and she also has a brother and sister. And she told me that they are always with her if she has to go in to have any surgeries. And they also go with her to doctor's appointments and help her make the medical decisions. So we have an activity that parents can do with their children, starting at a very young age. Let's see, you can switch the slide there. This is the sheet that you can actually, I think you could probably download this. I believe I sent this for the folder. So this should be in the resources folder for this, this presentation. And the idea is that the youth puts their name where it says my name, and they start thinking about who are the people in my life who can help me with these different decisions. This is something that I think teachers could use at school, families can use, actually for all of their children, not just their children with disabilities. Because it's important, I think it's important for all children to learn independence beyond their immediate family. So this, I think, would be a really great kind of ongoing activity. You know, this could be neighbors, this could be someone at church, this could be other family members that are not in the immediate family, people at school. I mean, Russell said that his supporters were teachers. I think you're still in touch with one of those teachers, right, Russell?
Oh, Nancy, for sure. But Marsha, I haven't really talked to her like quite a long time. She kind of moved away, and
yeah. But Nancy, I understand you still see her sometimes and hang out with her.
I try to hang out as often as I can, but she's busy too, and I know I'm busy too with a lot of different things.
Right. So it's like for all of us, our friends kind of come in and out of our lives. Just like for Russell and just like for the rest. Okay. And next, another tool that we actually got from the Missouri, let's see, I'm not sure. It looks like it's the Missouri Institute for Human Development at their USED, so their University Center for Excellence in Developmental Disabilities. So this came from their website. And this is just another visual way of charting the people who can be of assistance, the organizations that can be of assistance to a person, so that their kind of world expands beyond their home and beyond their immediate family. So I encourage you to start using these tools, production, but maybe just sit down for a few minutes, get it started, have it sitting around. Maybe you'll think about someone like, oh, you know, I understand that our neighbor is very interested in something that the child is interested in, and kind of add that neighbor's name onto the star chart. Okay. All right, so that's what we have for everyone, and I think I'm going to pass this back to Caroline. Thank you very much for listening, and I encourage you to go to the Board for People with Developmental Disabilities website. You can get a lot of the resources from that website. So thank you.
Thanks again. I appreciate your time and your been a pleasure being here.
All right. Well, thank you, Beth, and thank you, Russell. We really appreciated that presentation. A lot of great information from Beth and Russell, as the great information from George. So we do have one question. This would probably be directed towards George primarily, but Beth, if you have any input on this. The first question that came in was, if parents are divorced with joint custody, can they share guardianship? So George, I'll send that off to you first, if you could. Thank you.
Sure. This is George. Part of my practice is family law. I do divorces, child custody, parenting time, and guardianship would be a separate proceeding. If you get divorced and your child's a minor, you're going to likely have a determination about custody. In Wisconsin, it's called the physical placement, and then also legal custody. And the starting point is to have joint legal custody and joint parenting time and placement. When you get to be an adult, there would have to be, if your child has cognitive disabilities and a guardianship was deemed appropriate, that would be a separate proceeding that you would then go and petition the court to be guardians, and that would be, oftentimes lawyers will say, fact and circumstance driven. If through your divorced time you worked cooperatively and supported your child in both households, you did a good job of co-parenting, and that was demonstrated, that you're able to work out issues, be able to make the best decision for your child, that will be what can be utilized by the court in the guardianship proceeding. You can be appointed co-guardians. The challenge will be establishing the process or the procedures for decision making if there's, in a sense, a dispute. If there's, for example, a medical procedure that one parent guardian thinks is appropriate that another parent and / guardian does not, you need to maybe anticipate that and figure out how you're going to make that decision. So you can be appointed co-guardian, but the likelihood of that happening will, I think, be based on how well you did as co-parents of a minor child that you had when you were divorced. So it can be done, but it's going to be really dependent, I think, on what your experience has been. And I know this is an issue. I've been given other talks, and people have come up to me afterwards and said, we fought a lot. She got sole custody, but I'm worried because, and that can be brought up in the guardianship hearing, and that will play out based on the evidence that's presented to the judge, and they will make that determination. That's all I have.
Okay. Thank you, George. We appreciate it. Thank you. We have a second question for the whole team. And I'm assuming this question is in regards to both guardianship and supported decision making. The question is, does the team recommend going through this process with an attorney? George, if you'd like to comment on that first.
I do think going to an attorney for doing a guardianship is, and I'm not just saying because I'm an attorney looking for business, because this isn't a big, guardianship's not a big moneymaker. I mean, it's a big deal to those of us who are in this world, but in the larger world, there just aren't tons and tons of guardianships necessarily being done. So they're not a frequent case before a judge in a particular county. You go to rural counties, they may see 2 or 3 of these or one of these a month. But while they may not be numerous, the impact, as I tried to demonstrate in my presentation, are, you know, so significant and so far-reaching that it's important you really consider your specific circumstances and have somebody to do a sounding board of ideas off of, and to maybe find an attorney who understands a little bit more about guardianship than just, oh, I can help you do this. Where you can find resources of guardian, more savvy and experienced guardianship type attorneys would be with the elder law bar, because there's a lot of overlap between the attorneys who practice in the elder law section as people who practice in the area of disabilities. But to me, it's worth what the money you spend to help you really think these things through and have somebody. I mean, an attorney's role is sometimes to challenge their clients. I mean, sometimes I have to tell clients in my line of work things they don't want to hear, but they in fact need to hear it for their case or for their circumstance to resolve in the best possible manner, because they do make it easy. And I've had, you know, people come up to me with regret because they didn't fully understand, and that's what an attorney's role is to help you do. And when I look at sort of the impact and the long range reach, you know, how do you justify the expense? I'm speaking as a parent. I certainly could justify the expense. It's not going to be tens of thousands of dollars, but there will be some costs involved, and you can certainly call an attorney, ask them what they want for a retainer, what their hourly rate is, and go from there and at least make an informed decision. And if it turns out that you know, you use these materials that we've alerted you to, and maybe you have you want just a consult about one or two particular issues, that may be appropriate. But I would hate to think that a few years down the road, you know, you have this guardianship in place and maybe it's not appropriate as set up, and then you have to go back and redo it. And I can tell you, in most areas of law, redoing or undoing or changing something is more expensive and more challenging and harder than, you know, trying to do it right on the front end. So it's that cliche, penny wise and pound foolish. I think in terms of supported decision making, it's still real new. So I don't know how many attorneys really know a lot about it. It's designed really not to need to have an attorney involved. So that's one that I don't think you would need to have an attorney help you with, but you will want to do your research. You will want to take your time to understand and to identify your loved one's values and what it is they're hoping to accomplish. But supported decision making specifically was designed. I was part of the group that helped draft the legislation, as well as Mitch from Disability Rights Wisconsin, Hagopian, and we wanted it where you didn't have to have attorneys. But I would like that attorneys know about it, so that if they're approached about guardianship, they can ask, you know, parents or families to say, hey, take a look at this.
Yeah.
I'm done.
I also wanted to add, thank you, George. I also wanted to add that for the powers of attorney, healthcare, finances, you can download those forms off of the internet, and you do not need an attorney for those. You do need a witness generally, and for the supported decision-making agreement, you know, you'll need to have it notarized just to make it legal, but you don't need, it's like George said, the intent was to not require an attorney's involvement.
Okay, thank you, George and Beth, for that input. We do have one more, we have a couple more questions, but the next question is for Russell. If you're ready, please give an example of an important decision that you made without any supports. Can you think of one?
I actually had a relationship once I was in, and my ex-girl. I think it was the best decision I chose because she wanted to have kids and all that, and she wasn't thinking things thoroughly. So I just, here I am sitting there, I don't want to have to talk, to someone just because I'm uncomfortable. But I tried telling her a few times that I'm not ready for it. I don't have, I already have a few jobs in place, and I'm not really comfortable or not ready enough to do that. And she kept on going, and then that's when I had to tell her staff that I'm not comfortable with what she's doing, and things kind of got off haywire since then, but I just chose not to be that kind of person. My last bridge, the decision I had to make myself without anyone telling me to do.
Okay.
She wanted to have she said it only take 5 minutes, but she was stupid enough to do that stuff in her closet, and there was no doors, there's hardly no doors at all, curtain rods everywhere. And it's no.
So, Russell, can you tell us too about how you got your Zenith job? I think that's a great story.
I basically I went there and I got an application too, and I applied there, but then within a year and a half, I kept on following up with them every once in a while, and I kept on asking and asking. So, but then finally he said, come by at 2:30 and we can talk about it.
So you persisted.
Yeah.
That's great.
Okay, thank you, Russell. We have another question. This would be for George and Beth, most likely. So in the presentation, you mentioned that since the age 17 to 24 is such a period of continued maturing, so that the individuals are maturing a lot and changing in that time frame, age 17 to 24. So is there a type of hybrid or progression program from guardianship to supported decision making in place at all, so that, as someone said, at age 18, I can't imagine my niece being ready for many of those decisions, but possibly later on with some time and as she matures. So the question again is, during that time frame, if someone would take on guardianship, is there some type of a program that would help a family to look at and progress to supported decision making? Or probably even if guardianship wasn't instated at age 18, is there any type of program to help families look at the progression of the individual's maturity to make decisions along that time frame? Or could you envision one being put into place?
Well, George, the only thing I can think of would be Guardian ad litem, and I don't know how long those are put into place. I'm not familiar with, there is no temporary, I don't believe there's a temporary guardianship. You should probably take this one, George.
Yeah. I mean, when you looked at the form that I put up, there is a thing for temporary guardianship, but that's really designed for more emergency. Somebody has some serious chemical dependency issues, or somebody has, they went off their meds for manic depressive, and you need somebody to help them now and get them either in a treatment program or get a hold of their finances so that they don't run through them. This is still real new. There are no hybrids. I'd like to see more development going forward about what do we do for individuals in this 17 to 24 group, because the way the system's set up with decisions and precedent, if you get a finding of incompetence, I mean, that's what you set, and then you have to undo that. And now if you get more specific findings about their incompetences in this area, but all of that's what's going to drive the future, is when the court's going to look, because you may not get the same judge, you may have moved to a different jurisdiction, and they're going to look at what were the findings, what were what was put in place in terms of limited, in terms of the choices that they were given. I think as a practical matter, and speaking from my own personal experience of doing this for a couple years now, and I freely admit I probably have a different set of skills than maybe other families do, but there have been times where I wish I'd planned a little better, running into institutions saying, oh, well, we need a guardian, when in fact I know they don't, but picking my battles of whether I really want to fight this national bank in terms of what they will allow and not allow. But as we're in this transition period, if you think about, even if your child is 18 or 19 and they're going to continue in high school, they're very much likely to be living with you. Do you run the risk of them saying, I'm mad at you, I'm moving out? We can all make that hypothetical and terrify ourselves. But if you work with your child going, from the early ages, and using the tools that Beth pointed out to help them make decisions, and they feel they're able to come to you and not be judged and make mistakes and say, oh, we're going to learn from this. To me, the better approach is to go with a supported decision-making process. Learn where maybe the weaknesses are, or where they really do, on a go-forward basis after you've been able to test it, to say, okay, at age 25, we're going back in. We've talked about this with our loved one. And say, okay, these are the areas, we've tried these things, they haven't worked out, and they'll have a sense, I think, themselves of where they're at and where they really, okay, I need this kind of support. But over that length of time, they will have learned, you will have learned, and the society hopefully will be making some changes. So when you're in these formative stages of change, you're being a pioneer. You're definitely taking some risks, but you can, if there's a real crisis, you can go in and get a temporary guardianship because this person's about to make a really serious mistake, and we need to do something. And then you'll be back into court in 90 days, and you'll hopefully have developed maybe the petition for a more permanent guardianship to prevent disaster from happening. But right now there is no hybrid. I think hopefully in the future we will look at things differently about guardianships. I know there's a group of us now thinking about, what about guardianship reform going forward? One of the things, if you do believe in a guardianship is appropriate, is put it in the court order that says you're coming back in a year, where you force yourself. Because if you just put a guardianship in and say we're going to come back, the court's not aware of that, there's no mechanism to require you to come back unless you have it actually in the court order and you're required to come back vis-a-vis the court order, and you kind of put that onus, that burden on you, and say, yeah, we're coming back. So we're going to have to tell a judge something about our situation, as opposed to, we plan to come back, but life happens, and 4 or 5 years down the road, if you're not required to come back, you may just keep doing what you're doing, and then whatever you have in place will eventually, more than likely, pass on to somebody else. So that's my response to that one.
Thank you, George. Any other thoughts on that, Beth?
No, I think, it's like George said, there is no, that is something that BPDD sent out a survey, and that was something that quite a few people requested. It was some kind of interim something I'm not sure what you would call it, but right now we do have a lot of other tools. We have all the powers of attorney that do give a lot of, I mean, that they would allow the person who holds the power of attorney to have full control over healthcare or finances. So that is an option.
Okay, thank you. We have one more question. This is for George. So George, this is a question. My divorce was after my child turned 18, and both of us have guardianship. We put information about who makes decisions attached to the divorce document. Was this the best way to address the issue? My ex wants to change some placement issues. Do we go back to court and make it part of the guardianship papers?
Okay. I think it was appropriate to put the information into the divorce document to talk about how you're gonna make decisions because you're gonna be involved in this child's life. I mean, when I do divorces, you know, whether your child has a disability or not, I sometimes have to point out the obvious. You're going to be involved in your adult child's life. They're going to have college graduations. They're going to have marriages. They're going to have children, and they're going to be grandchildren, birthday parties, and christenings, and their events. And if you can't find a way to co-parent or to get along, you're going to it's going to be draining for you for years to come, and you're going to be putting your adult children at some point in time, you know, making decisions about, you know, who sits where at a get together. And, you know, the same thing is true when you have a child with a disability and you need to help them in their life going forward. You want to put something out there in writing so that if you do need to go to court, and I don't advocate always going to court, that the court has a starting point. You know, sometimes in the past we say, oh, we're going to, you know, one parent's going to have primary placement and they're going to have parenting time, and the other parent will have reasonable parenting time. Well, I don't know what your definition is of reasonable parenting time. I don't know if you go into a judge what their definition of reasonable parenting time is. But if you define for your family, this is what we mean by reasonable, and should, for whatever reason, because of life circumstances changing, that changes, at least the court, if you have to go back, has a starting point. So I think it's always helpful to have what we call in the legal profession findings, so that the court knows, oh, back on this date, these were the findings. This is what the parties agreed upon, and now we're moving from there. It's really difficult when there's no starting point, and people try to do revision history. Well, this is what I meant back 4 or 5 or 6 or 7 years ago, and oh no, this is what I thought you meant. And so you're having in a sense, a fight about the past and interpretations of it, and the court has to reconcile, you know, the classic he said, she said, if you will. So anytime you can put things in writing, it's helpful. You don't have to go back to court if you're able to either come to an agreement because you've set up a process for doing that, or you enlist others to help you. There's nothing that I do something called collaborative divorces, where we use other professionals like a child support specialist or a financial neutral to help us arrive at decisions. It's not to say that you can't go to a mediator and say, you know, we're having issues communicating, and it's getting in the way of us helping our child, you know, have a better life for whatever reason. I'm not making a value judgment here. So then go and find somebody and get some help with that process so that you can focus on solving that problem and not get caught up in maybe some of your past triggers or some of your you know, past grievances. And you can really focus on, okay, what do we need to do that's in the best interest of our child, and use the services of a mediator, use the services of a therapist to help you arrive at that. And then if that process gives you a framework, you know, put that in writing and then ask that to be made into a court order so that you can build from that. But the court really likes to see people making their own decisions. and they don't want to substitute because they don't know your family as well as you do. But they're in a position, and our laws are set up so that if people can't come to a reasonable, agreement, they'll do, based on the evidence, they'll make a decision for you. They'll substitute that. So you don't necessarily have to go back and make it part of the guardianship papers. I would, if you reach a new agreement, put it in writing, both sign it, date it, each have a copy of it, and see how you can move forward in that way. But you can certainly go back in and have the guardianship modified in certain respects based on the changes, and the change in circumstances. Because again, if you're looking at, this is going to move on to maybe somebody else in the future, a sibling, that might be appropriate. I'm done.
To you, I think it's a good idea. We have, this is all brand new, as George just said, but I know we've been talking about the importance of taking it to the bank, making sure that the bank is aware that if your son or daughter shows up for at the bank, wants to withdraw some money and comes with someone, that bank knows who that is and has the form on file. Same with the doctors, make sure that they all have a copy of it. Just kind of make sure that people who are involved have a copy of it so that they can take that with them and list it on the agreement. But there's no specific filing with the court or anything that's necessary.
Okay, thank you, Beth. That will end our webinar for this morning. So we want to thank all of you for attending and participating. We hope that you gained some useful information from this webinar. And remember that we will be sending out a link to our electronic folder with all the resources that we mentioned today, and maybe adding a few other ones. Also remember that we gave you contact information for Beth, Russell, and George, and I think they would welcome any questions that you might have for them after the webinar. So again, Rita Fuller, our WSPEI Grant Director, is here, and myself, and we would like to thank you again for participating in our WSPEI webinar. We will be having these again next year, so keep on the lookout for new topic areas. So thank you again for attending today, and have a nice afternoon.